Like many places, Australia is reevaluating its response to intimate partner violence. Terminology for just a moment. So in the United States, we are starting to use the term intimate partner violence as opposed to domestic violence or family violence, which I understand is the most broadly used term here. I'll use them interchangeably, forgive the intellectual sloppiness of that. It's really about terminology and transition. Also, when I talk about people subjected to abuse, I try to avoid either the term victims or the term survivors. They're both kind of politically loaded in the domestic violence movement. I will often default to talking about women subjected to abuse, largely because I've done this work with women for about 20 years, and also because in the United States, the vast majority of victims of intimate partner violence are still women. But what I mean to say, and what I have worked on quite a bit, is saying people, because we want to acknowledge that there are men who are abused both in straight and in gay relationships, and it's important that we're not exclusive when we talk. So, my understanding is that Australia is reevaluating its response, and I hope to share some thoughts from the US experience so that they might be helpful to you as you contemplate the kind of changes that you might make. As MP Donaldson said, I've been a lawyer working with people subjected to abuse for the last 20 years. And when I started doing this work, I truly believed that the law was the best way to address the problem of intimate partner violence. That changed for me when I was doing a divorce with a client who had been abused by her husband, had several children with him, and I thought that I was doing the Lord's work, really, right? I was doing the last thing that would sever her permanently and completely from this abusive man. And I said that, not in so many words. As a 24-year-old lawyer, I said to her, "Aren't you so excited?" And she said, "No." She said, "I didn't want to get divorced. This isn't where I imagined that I would be. And I have children with this man. And it's all a lot more complicated than you, my 24-year-old unmarried, childless, legal services attorney, that you really have any idea of what this is like for me." And that was really the turning point for me in terms of thinking about intimate partner violence in a much more and the law's relationship specifically to intimate partner violence in a much more complex kind of way. I really did believe then that law was the best tool for dealing with intimate partner violence, and that it was primarily a legal problem. And I thought that we had done well in the United States to make the law the primary means of addressing domestic violence. And make no mistake, in the United States, law is the best funded, best developed regime for addressing intimate partner violence, and particularly in the United States, the criminal law. And so that's the choice that we've made. I agreed with that choice. After 20 years of practicing law, I don't agree with that choice anymore. The legal system serves some people in the United States well, but it serves some people poorly, and it serves some of them not at all, and it affirmatively harms some of the people that it was meant to help in the first place. To serve people subjected to abuse, I think that we need to think beyond the law, and I think that we need to rethink the legal response to intimate partner violence. Those are the things I'd like to talk with you about today. But just to give you a little bit of background. So in the United States, we have a comprehensive federal law called the Violence Against Women Act. The Violence Against Women Act grew out of about 10 years of advocacy that started in 1984, when the US Attorney General's Task Force on Family Violence declared that domestic violence was a criminal problem. This was absolutely unheard of in the United States. No one at that time, I think, was really thinking about intimate partner violence as a problem of the criminal law. From 1984 to 1994, there was a tremendous amount of advocacy by the battered women's movement to get comprehensive federal legislation to fund and to train and to equip courts and police officers and prosecutors to do this work using the criminal law. And in 1994, we got the Violence Against Women Act, which does that. Since 1994 in the United States, hundreds of millions of dollars have been poured into the legal response, and primarily the criminal justice response to domestic violence. So we have, in fact, funded fairly significantly the criminal law regime in the United States. In the United States, rates of domestic violence have fallen since 1994, but they've fallen at exactly the same rate as the crime rate overall was falling. And that happened from 1994 to 2000. From 2000 to 2010, rates of domestic violence actually fell less than the overall crime rate fell. Again, at a time when we were pouring hundreds of millions of dollars into the criminal justice response. So there's no social science research in the United States that ties the drop in the rates of domestic violence to the increase in the criminal justice response. I think if there were, people would be trumpeting it very loudly. It would be nice to justify some of those expenditures. We can't do that currently. And I think what the disproportionality and the falling of the crime rate shows us is that there's a lot more going on than a criminal justice response necessarily can deal with in the case of intimate partner violence. And I think that should cause us to stop and ask whether what we're doing is actually effective or not. In my book, I identify 4 major problems with the legal response to domestic violence, and I'll talk about each of them kind of briefly in turn. First, the legal response to domestic violence in the United States is excessively focused on physical abuse. And as a result, it creates far too narrow a definition of domestic violence. I know that that is not as true here as it is in the United States, but I also know that the parts of the law that pertain to, say, economic abuse and emotional abuse are not nearly as well used as the parts that pertain to physical abuse. And I think that we have a common problem, in that our understanding of domestic violence is really driven by the hit, the kick, the punch, those very visceral forms of physical violence that it's easy for people to see and to understand it. But what I've learned from my clients over the last 20 years of advocacy is that that is not the abuse that is most difficult for them to deal with. It's not the abuse that leaves the most damaging consequences. And let me give you an example. I had a client who had been married to an incredibly abusive man for 19 years. But this is what the sum total of the physical abuse was in their relationship. He took his fist, he bopped her on the head, not much harder than I'm doing to myself, possibly 4 times over that 19 years. Over that same span of time, though, he locked every door and every cabinet and every cupboard in their house, and he kept the keys. If she wanted food, if she wanted cleaning supplies, if she wanted a new roll of toilet paper, if she wanted feminine supplies, if she wanted towels, or access to the laundry, or access to the computer while she was working on her master's degree, she had to ask him. Or sometimes their eldest daughter, who had been empowered with the keys, but she was never allowed to have them. If she needed a new roll of toilet paper, she had to turn in the old spindle. If she needed to wash clothes, she had to show him that her clothes were dirty. If they weren't dirty enough, she didn't wash clothes, which meant that she often went to work in dirty clothes that had been worn the day before. If she wanted money, she had to submit a 3x5 card. Oh, I'm dealing in inches, you're dealing in centimeters, I don't know how big that is. She had to submit a small paper card detailing what it was that she wanted and why she wanted it. And that request could be approved or denied for any reason, including, you've been a bitch, you're not getting the money. Over time, he forbade her to eat at the family dining room table with everyone else. She had to eat standing up in the kitchen. Over time, he would interrupt any time that she started to talk, telling her that they were not interested in what she had to say. He told her that she was a terrible mother, that she was a terrible person, that she was worthless. And during her divorce trial, her friends testified that at the beginning of the relationship, she had been a happy, well-adjusted, assertive, ambitious woman. And she was none of those things by the end of that 19 years. By the end of that 19 years, she had been systematically disassembled as a person. And it wasn't about the physical abuse. It was about that daily, ongoing emotional abuse that the law in the United States, by and large, does not touch. So in most places, and I think it's true in many places in Australia as well, we don't have law that particularly deals with emotional or psychological abuse, with economic abuse, right? The taking away of somebody's access to resources or the denial of the ability to gain resources on one's own. Reproductive abuse, right? Getting someone pregnant purposely to keep controlling them or denying them access to the ability to control their own reproductive health. Spiritual abuse, which is something that we're seeing more in communities in the United States, like the Orthodox Jewish community, where you deny somebody the ability to act out their spiritual life in ways that really get to the core of someone's identity, in ways that physical abuse doesn't, right? And the law doesn't touch these things. And there's some question, I think it's fair to ask, whether we would want either the civil or the criminal law to touch any of those things. It would be very difficult, for example, Heather and I have been having this conversation. If you really started to criminalize emotional abuse, I would be very worried that the first people who would be prosecuted would be nagging wives, right? So I think the law doesn't touch the kinds of abuse that are most harmful to my clients, and I'm not sure that I want it to. I'm not sure that it's designed to do that work. The second problem that I identify with the legal system's handling of intimate partner violence has to do with the way that the law characterizes particularly women who have been subjected to abuse. So I throw around the term essentialism for those of you who are not reading in this theory and who just don't care that much about it. Essentialism is just the idea that there is one unified idea of woman, and for our conversation, one unified idea of woman subjected to abuse. And that they're all supposed to look that way, and if they don't look that way, well then they can't possibly be abused. This essentialization of women subjected to abuse plays out in a lot of different ways, right? That judges have particular expectations of the women that they're going to see in their courtrooms. They are supposed to look a particular way, and the way that they are supposed to look is largely dictated by work that was done in the early 1980s by an American psychologist, at least in the States, named Dr. Lenore Walker. It was Lenore Walker's 1979 book, The Battered Woman, that really set out for the first time the image of what a victim of domestic violence looked like and created an expectation about what you were supposed to see. So in Walker's work, we get a victim who is passive, weak, meek, unable to fight back against her abuser, unable to do anything to remedy her condition, right? And that's the image that gets brought into the law, at least in the United States, by things like battered woman syndrome, which is now an explanation but not a defense in many places in the United States. And so because we've imported these ideas that come from Walker's work about what victims of domestic violence are supposed to look like, if you come into that system and you don't conform to those stereotypes, it can be very, very difficult for you to find help because you're supposed to look a particular way. What this ignores is that these stereotypes are largely white and they are largely middle class. They are certainly heterosexual, and they're built around a very kind of specific woman who doesn't necessarily fit the profile of many of the women that we serve, and certainly doesn't fit the profile of many of the women who are most disadvantaged by dealing with abuse. Low-income women, women of color, LGBT people, particularly transgender women, women in rural communities. So those kinds of stereotypes, when they don't apply, make it significantly more difficult for women to find justice within the justice system. And in the United States, these were political choices that led to the creation of this stereotype, right? It was an appeal to the white middle class power structure to say, it's not just domestic violence happening in low-income communities of color. This could be your sister, your mother, your daughter, although certainly not your wife, who this is happening to, and because it could be part of your family, you should care about it. That was a specific political choice made by the battered women's movement in the United States, and it was successful, right? It brought, and you see it in the rhetoric from that time where people are saying it happens to everyone, it happens to you, it could be you, right? And that's what brought money to the problem. So it was a very successful kind of choice, but a very problematic one nonetheless. These passive stereotypes are really problematic for women who fight back. And there are lots of women who fight back against their abusers, and they do it for lots of different reasons. They do it because they want to stave off someone else's attack. They do it because they're angry. They do it because they're frustrated. They do it for lots of reasons that take them off of the binary that we've created, right? Where we have angelic victims and demonic abusers. Well, my woman who fights back is not an angelic victim. She's a person who gets angry or frustrated or upset or wants to protect her children or thinks she can stave off something else that's going on in that moment. But it certainly takes her out of the realm of the perfect victim and makes it much more difficult for judges to appreciate the help that she needs. We've had a particular problem, and this is something that Professor Douglas has written about, with mothers in the United States and the intervention of child protection as a result of mothers either taking action that seems inappropriate or not taking action at all. So if you're a passive mother and you don't take action to protect your child, then you are failing to protect, and child welfare needs to step in and help. And if you are an active mother and you actively take your child, say, for example, to another country to prevent the harm, then you are in violation of the Hague Treaty on international parental kidnapping, right? So there's a real problem that's created for mothers who act in ways that are outside of these kinds of stereotypes on either side of things. And these stereotypes can be particularly harmful because they multiply the credibility issues that women face from the moment that they walk into courtrooms. So from the moment that you make an allegation of domestic violence, you are at question, right? And we've heard a little bit about it from the perspective of judges who say we are concerned that people are misusing the protective order process in order to gain advantage in custody cases or in divorce cases. I've heard that in Australia, and I can't tell you how many times I've heard it in the United States. And that credibility question is a really problematic one, because what that means is that when you walk into a courtroom to get assistance, you are already questioned. Your credibility is already at issue. And if you don't conform to those stereotypes of what a perfect victim looks like, your credibility is really shot. So this essentialization of women is problematic in that it creates stereotypes that women can't possibly live up to. And in so doing, really undermines their ability to get help through the justice system. The third problem that I articulate in the book has to do with the idea of separation. So our system operates on the idea that separation is the best possible response to domestic violence. It assumes that all women do want or should want to leave their abusers, and that they will do so if they're only given the tools to do so. And the tools that we've created in the legal system are largely separation-based tools, if you think about it. Arrest, prosecution, incarceration, protective orders, divorce. In the United States, some of our immigration remedies, for example, the U visa, which is a visa available to victims of crime, is only available if you are willing to help police investigate a claim against your abuser, which again is a separation-based option. So separation-based options would be fine if we thought that separation actually stopped domestic violence, and if we were right that every woman wanted to separate from her partner. But both of those things are untrue. So first, as to separation ending violence, anyone who is in this field, those of you who are sitting here, can tell everybody here just better than I can about the ways in which separation actually exacerbates violence rather than diminishing it. Separation, the cliche, separation is the most dangerous time in any abusive relationship because what that says is at that point you no longer exert power over me, I'm going to go out on my own, and that creates an enormous amount of danger for a person subjected to abuse. And the statistics bear this out. Separation-based assault is a very real phenomenon. Martha Mahoney named it in the United States in the early 1990s. It is as true now as it was then, that separation-based assault is very real, and that the tools that we give people to try to protect them from separation-based assault don't really work if somebody is determined to assault them. So, I have this kind of split relationship with the idea, with the phrase, a protective order is just a piece of paper. Is that something that gets said here? It gets said in the States all the time, and on the one hand, you want to say, no, it's not. It's a piece of paper that's imbued with the power of the state and a criminal sanction if you violate it. But as against a weapon, a protective order is just a piece of paper. And really what that means is that a protective order will protect someone if the person who is subject to the order will abide by it. But if the person who is subject to the order doesn't particularly care about the criminal consequences of violating it, or more importantly, I think for some of our purposes, believes that there will be no sanction if they violate it because there is no viable enforcement mechanism or because orders are under-enforced, they are just a piece of paper, right? So the tools that we give people to achieve separation are limited at best. And so separation, not necessarily a good thing in terms of the efficacy of separation as a tool of keeping people apart. As to the second point, that all women do or should want to separate from abusers, they don't. I have lots of clients who would very much prefer to still be in relationships with the people who abuse them. They just want the violence to stop. And what we haven't done is to really think through how you can stop the violence rather than just issuing orders. We haven't really grappled with why people stay in abusive relationships. And within the battered women's movement, I think one of the gravest disservices we've done is that a kind of a strain of the literature that describes love as traumatic bonding, right? And refuses to accept that there are people who genuinely love their abusive partners. And it really goes back to the story that I told you in the beginning, that the woman that I was dealing with had a long-term relationship with her partner. They had been together for a very long time. They had children together. They were emotionally enmeshed. They were economically enmeshed. She had a valued relationship with him. And what we do with the law in the States, at least, does not acknowledge the values that relationships have to the people who are in them. It simply says if it's an abusive relationship, it needs to go, and we're going to achieve that through separation. And I think that's really problematic. Finally, the fourth criticism I have of the legal system has to do with something that you don't necessarily have here, and I guess if I achieve nothing else, it'll be to keep you from doing it. In the United States, in order to implement a lot of our law and policy, we have adopted what I call mandatory policies. So, for example, in the first iteration of the Violence Against Women Act, an idea called mandatory arrest came to the fore. Now, mandatory arrest is the idea that anytime police go to the scene of a crime of domestic violence, they must make an arrest if there is probable cause to do so. Mandatory arrest grew out of the frustration that advocates had over the police's complete unwillingness to make an arrest ever for any reason. And if you look at the police training manuals of the 60s and 70s in the United States, there's a piece of urban legend that is actually contained within them. So in the United States, the urban legend was, police would always come and they would tell the guy to take a walk around the block until he cooled down. And that is actually the advice that is given to police in the training manuals of the 60s and 70s. Not determine whether an assault has occurred and make an arrest if appropriate, but tell the guy to take a walk around the block. A big focus of the battered women's movement was moving us from a place where domestic violence was considered a private activity, not the province of the state, to a public concern, one in which the state should intervene. And mandatory arrest was meant to do that because basically the battered women's movement in the States simply did not trust police to ever do their jobs properly. And so in thinking about this as a pendulum, we had a non-intervention place and we swung it all the way to a mandatory intervention place where police had no discretion to determine whether a crime had occurred. Well, they had discretion to determine whether a crime had occurred, but they had no discretion about whether to make an arrest or not. So anytime police come to the scene, in many jurisdictions in the United States, they must make an arrest. Some jurisdictions have backed off this a little bit to a place called preferred arrest, which is if you show up at the scene and you have probable cause to do so, we prefer that you make an arrest, but we allow you a little room for discretion. Having dealt with the police, the battered women's movement then turned to prosecutors and said, well, now we've got cops making all these arrests, why are you not prosecuting? Because rates of prosecution remained ridiculously low after the inception of mandatory arrest. And prosecutors said, well, we can't prosecute because our star witness, the person who's been abused, doesn't want to do it. And we can't do it without her. Two things kind of happened in response to that. One is something that I think is a good thing. It's called evidence-based prosecution. And the idea is that you investigate a domestic violence crime the way you investigate a homicide, as though you have no viable witness to come and testify as to what's happened to them. That means you have to collect the physical evidence, right? You take pictures, you take statements, all the medical records, right? All of the things that you would use in a homicide case, you would use here too. And I think evidence-based prosecution is a good thing. Right? As a general rule, police should do their jobs in terms of collecting evidence at the scene of a crime. But the other thing that happened was that prosecutors said, well, we think that the reason that women aren't going forward is because they're so controlled by their partners and they so don't know what they want and they don't know what's good for them. And so we're going to make that decision for them. And we're going to do what's called no-drop prosecution. And we're going to bring forward any case where we have viable enough evidence to do so, regardless of whether the person who's been abused wants us to do so or not. We can have a debate about coercive control. And we can talk about how many people are so significantly coercively controlled that they are unable to exercise any rational thought on their own behalf. And we can talk about making choices under conditions of constraint, which is what most of us do on a daily basis. We all make choices under conditions of constraint. The choices that people subjected to abuse make are different constraints than the choices that I make. But I will tell you that in 20 years, I have had a handful of clients who were so coercively controlled that they could not express any desire or give me any idea about how they wanted their representation to go forward. What no-drop prosecution does, though, is say that no one has the capacity to make a choice on her own about complying with prosecution. And therefore, the state has the power to make that choice for her. And so power in this case is in some ways a zero-sum game, right? Somebody gets to hold all of it. Either the state makes the choice or the woman makes the choice. There isn't a lot of collaboration, although in my ideal world, that's where we would be. But at this point, power is a zero-sum game. And what we've done in the states is to give all of the power to the state in the form of police to make arrests without women saying, I don't want an arrest made, right? I might want you to come and break up this event that's happening right now, but I don't necessarily want my partner arrested. I need him around for parenting support, for economic support, because I love him, because he puts a roof over our head, for the myriad reasons that those of us who do this work know that people stay in abusive relationships. Or I don't want to prosecute because I think it'll make things worse, because I am not interested in engaging my partner in state-based carceral systems, because as a woman of color in the United States, I don't want to be responsible for yet another man of color going to jail, and we can talk about those statistics. They're pretty stark. There are lots of reasons why people don't want to be part of prosecution, but the state gets to make those choices. And so I think that's an incredibly problematic thing that we've done. And in the States, you should know that no-drop prosecution, when taken to its logical extremes, has occasioned such things as women being arrested, well, women being subpoenaed to appear in court, women being arrested for failing to comply with those subpoenas, women being incarcerated as material witnesses until trials occur, women being prosecuted for perjury when they make statements that are inconsistent with the statements that they make at the scene of the crime. We don't know systematically how much this is occurring. We don't have a good empirical study that says it happens X number of times. I will tell you anecdotally, it happens enough to make me worried about it. And I read enough stories about it to make me worried about it. I think this is a really problematic thing that we've done. And again, if there's one thing I can tell you not to do, it would be to take these kinds of mandatory policies. There is no evidence that mandatory policies decrease recidivism. There is no evidence that mandatory policies keep women safer. Now, the argument that you could get on the other side of that is, how do you know? We have yet to fully implement them. And in the United States, we kind of have a twofold problem of under-enforcement and over-enforcement. In some places that have these policies, they have not been fully implemented for various reasons. And so you continue to have the police non-intervention problem as opposed to the police over-intervention problem. But even if there was better evidence of their effectiveness, I think there would still be significant cause for concern. And that has to do with the autonomy and the agency of people subjected to abuse. That we, in pursuing these kinds of policies, we have made a policy judgment that people subjected to abuse are not capable of making decisions about the most important relationships in their lives, things that affect them, their children, their emotional well-being, their economic well-being, all the facets of their lives. And I think that's deeply, deeply problematic. And you know, it's interesting that as we get new kinds of innovations in criminal justice enforcement, these concerns come to the fore again. So I recently read an article, and I can't remember which state it's from, I'm really sorry, about using video at scene to better prosecute domestic violence cases. And on first blush, that's exactly the kind of thing that evidence-based prosecution wants, right? If you take video at scene, then you have a better sense of what's happening. But if you take video at scene, it's a lot easier also to disregard somebody's wishes about prosecution if they choose not to comply going forward because you have video. And so in thinking about the kinds of innovations that could help with criminal justice reform, it's important too to think about the ways that they could be misused, and as you start to use them, build in safeguards that will prevent those kinds of misuse. So let me be very clear about something. I'm not advocating for the end of the criminal justice system or the end of the legal response to domestic violence. I want that system to work. For people who want to use the legal system, I want that system to work. I am still a part of that system. I work in that system day in and day out. I am invested in it doing what it's supposed to do. And so to that end, I think one of the important things that we have to do is think about what a reconstructed legal response would look like. For me, the one thing that I've heard time and again is that the two things that people subjected to abuse want more of is time and information. So time to make decisions about whether the state is going to intervene in their relationship is only made meaningful if people have real information about what it means to be engaged with the state. So one could imagine a system in which police come to the scene of the crime and they separate the parties as they've been taught to do, and they understand that a crime of domestic violence has occurred. And then they say to the person who's been abused, it's our understanding that a crime of violence has occurred. We believe that you are the victim of that crime. Here's what's going to happen next. If we make an arrest, that person is going to be taken in the state system to central booking. And they're going to be booked in as having committed X crime, and that crime in the states is likely to be a misdemeanor. and it's likely to carry 6 months of jail time, although it probably won't. In the United States, we still have ridiculously short sentences, even for significant amounts of domestic violence. But it's likely to be booked as a misdemeanor. He's likely to be in central booking for 2 hours, for 4 hours, for overnight. The bail is likely to be this amount of money. Do you have a place that you want to go in that amount of time? Can you make arrangements in that amount of time? If we make this arrest, does it make you safer? Does it make you less safe? And to have that kind of conversation that will enable police on the scene to make an informed choice about whether arrest is actually going to benefit the victim, whether it's going to meet the victim's justice goals or not. Because that, for me, is the central concern. What are the justice goals of the person subjected to abuse, and how do we best meet them? Now, is this an ideal system? Absolutely. Do I actually see police doing it anytime soon? Absolutely not. But I think as we move towards kind of a better legal system, that has to be the place that we're looking, right? Similarly, in dealings with prosecutors, prosecutors would talk to people subjected to abuse long before any prosecution is going to take place. In the States, generally prosecutors only talk to you pretty much the day of. And the caseloads are huge. They don't have a lot of time. You might hear from a victim witness advocate a little bit before, but only really to get you to show up, not to talk through your options. So if he's prosecuted, it's likely to be a second degree assault, which is a misdemeanor. And the potential jail time is 6 months, though most judges don't give that. He might not spend any time in jail at all. And if we do the prosecution, you're going to have to get on the stand, and you're going to have to testify to what happened, and then you're going to be cross-examined. And when you are cross-examined, here are the things that you are likely to hear, and here's what that experience is likely to feel like. Is that something you want to do? And prosecutors, again, would take time and provide information that would allow victims to make better choices about whether they want to be engaged with these systems or not. In addition, we might think about other kinds of justice practices that can run either parallel to or in conjunction with state-based practices, things like restorative practices that might give us other options in terms of dealing with the legal system's response. For those people, though, who don't want to engage with state systems for whatever reason, I want there to be options for them as well. And so one thing that I think a lot about is justice beyond the justice system. So we in the United States have really delegated the responsibility for seeking justice to the state. And individuals have very little stake in how justice is gotten for them, even though they are the victims of the crimes that bring these things to state attention in the first place. For those folks who don't want to prosecute, who don't want to arrest, but who want justice in some form, we need to be thinking about the kinds of processes that could provide them with justice, whatever that means for that individual. And I was having a conversation with Kathy and with Elena this morning that kind of has my head spinning in a lot of ways about thinking about how we structure these kinds of justice interventions, what are the principles that we organize them around, but I think we agree that the principles of voice and validation and vindication are among the most important things that victims say they need out of justice systems. So how do we provide those opportunities for voice and validation and vindication? That could be through restorative practices, but only if they're done right. And so in the domestic violence movement, one of our real concerns has consistently been about mediation, about restorative practices. Are these things going to just further the power imbalances that already exist between the parties? Are we creating situations where victims feel unsafe? I think we have to be attentive to those things, but I think to write them off is a mistake. Those of us who care about the possibilities of justice beyond state-based systems need to be invested in creating those programs and doing those programs and monitoring and evaluating those programs to make them as safe as humanly possible for people subjected to abuse, but also in making them places where people can exercise to find their justice goals, to achieve their justice goals. I've been thinking about ways that we might use community justice forums, modeled after some of the informal justice work that's gone on, both in response to atrocity through the Truth Commission process and kind of justice on the ground through things like the Nari Adalats in India. Ways that we can create community-based justice that's centered around these ideas of voice and validation and vindication. A second thing that I think we need to really be thoughtful about is economic stability. So the research in the United States shows that when men are under or unemployed, they are more likely to be violent. This is not terribly surprising. We might do more to decrease men's violence by creating job training programs for them than we do by putting them in jail. Putting people in jail, just kind of in the States anyway, creates this vicious, problematic vicious cycle around economic instability. You go to jail, you come out, you can't get a job. So you're underemployed or you're unemployed, you're more likely to be violent. You go back into a dysfunctional community, community dysfunction is strongly tied to domestic violence. And then you make your community more dysfunctional by engaging in domestic violence, which then sends you back to jail. This is not solving a problem. So we need to think structurally, and I think one of the things I would fault my book for, and something that I've kind of come to later, is that it doesn't grapple enough with the bigger structural factors, like economics, that really drive a lot of what we're seeing in terms of abuse within communities, and I think we need to be thoughtful about those things. We need to engage men. We need to stop treating men, and here I really do want to go back to gender binaries because I think this is a very gendered thing that we do. We need to stop treating men as demons. Men who abuse are men who abuse. They're not demons, they're not monsters. My clients are really uncomfortable when their partners are treated that way because what does that say about you? That you've chosen a monster or a demon to have as your partner. And we're not achieving change by treating men that way. Men's abuse of women can only be stopped if men stop abusing women. So we need to focus on changing men's behavior, and we're not going to do that by telling them that they are horrible people. In the United States, the research on offender intervention is mixed. Paul gave great statistics the other day about some more promising stats coming out of offender intervention, and I think good offender intervention programs are absolutely part of what we need, but so is access to economic opportunity, and there's a bigger issue that we haven't grappled with in the movement at all, which is about why men are abusive. So in the movement, we have accepted that abuse is about power and control. And if you ask anybody who knows anything about domestic violence, they will say to you, abuse is about power and control. I think power and control is the outcome of abuse, but I'm not positive that the research supports the idea that it's the intent. And Ellen Pence, who started the Duluth Abuse Intervention Project in the States, which is one of the projects that has really been widely adopted throughout the world, said something like this in a couple of interviews before her death. She said, basically we saw what we wanted to see. We thought it was about power and control, so we imputed that as a motive to the men. But the men weren't necessarily saying that. I think we need to know from men what it is that causes them to be abusive, because we're not going to change the behavior until we understand what's motivating it. Now, maybe it will be power and control, but maybe it's not. And if it's not, that explains why some of the techniques that people use in offender intervention programs aren't as effective as they might otherwise be. Finally, and I realize that I'm very close to time, we need to think about community accountability strategies. There's some really great work going on in the United States about engaging community in the job of policing intimate partner violence. We've largely ceded the role of enforcement of the law to the state, and we've really kind of given up the community's role in any of this. Community accountability says there is a role for the community to play in recognizing, responding to, and holding people accountable for their violence. And so part of what we want to do is enhance the community's capacity to recognize and intervene in abusive situations, to support people who've been subjected to abuse, to confront abusive people with their behavior, and to create processes that ensure offender accountability and transformation, and in turn, then, to articulate these norms to the wider community so that we start to do some of the preventative work that we say that we care about, but that a back-end legal system can't really do particularly well. So we would provide community with the resources in terms of tools and models for intervention. There's an amazing project run by a woman named Mimi Kim, called Creative Interventions in the Oakland area. If you're interested in these ideas, look at Mimi's work. I think it's absolutely brilliant. And then we need to be focused on the larger structural forces that create and contribute to intimate partner abuse in the United States. That's economics, that's housing, and that's racism. And until we start to deal with some of the systematized racism that we have in the United States, we will never have communities of color feeling comfortable engaging with our systems. So, fair critiques of all of this. It doesn't go far enough. Right? There are people who would say, until we get rid of the criminal justice system all the way, we're never going to get anywhere. Some people say it goes way too far. The big criticism that I get when I give this talk a lot is people in the United States are very, very afraid to give up our mandatory policies. They feel very afraid of giving police discretion and giving prosecutors discretion. What I get a lot is, well, you're going to return us to the bad old days. I don't think that's true. I think that you can see it in countries that don't have mandatory policies. There are different issues, but they aren't those issues necessarily. And then the biggest critique, and I think it's fair, is how are we going to do any of this? And I think that's the task that we all have to be engaged in together. I am not arrogant enough to think that I can tell you how we could do any of this. I think if we think these are decent ideas, then we need to start talking about them, and we need to figure out together how we do this stuff. But I will tell you, at least in the United States, we are not going to prosecute or incarcerate our way out of this particular problem. In 2009 to 2010, in the United States, there were 907,000 reported acts of intimate partner violence in the United States. If we prosecuted all of them, and the current prosecution rates are 64% of cases are prosecuted where an arrest is made, 27% overall are prosecuted. If we prosecuted all of those cases, and if each of those cases resulted in conviction and incarceration, we would have added to what is already the largest incarcerated population in the world, right? Our 2.2 million who we already have in jail, without really addressing the problems that are at the root of any of it, and with creating a huge problem for ourselves on the back end when all of these people come out of jail and simply start to cycle through again. Arrest and incarceration are not the answers here. You need a criminal justice response in those cases that really need a criminal justice response, but we need to be thoughtful about what our other possibilities are as well. Thank you.
I'm not even going to begin to try and say anything erudite after that. That was wonderful. Thank you very much. Leigh has graciously agreed to take about 10 minutes of questions, so can I invite you, please?
I've left you speechless. Zoe.
I'll have something. Well, thank you so much. That's so interesting, and I'm sure makes us all think a lot. And it is very interesting. There are some different paradigms in the two countries and all the different states as well in both places. And those, some of those ideas then you think about what happens if they're here. But the particular thing that I wanted to ask you about, poor Heather knows this is my obsession at the moment, but one of the things that's happened here in Australia is this idea of the typology literature becoming so entrenched in our various systems, particularly I think in the family law system. And one of the things that I see happening out of that in the cases when you read what the judges are saying, and I think that this is, as always happens in family law, that'll start to spread into the way that lawyers advise their clients and others, is that there's now this concept, and it partly relates to the way that the new definition got put into the Family Law Act, that unless violence is coercive and controlling, it's actually not domestic violence at all. So an idea that was originally, look, it's a bit like what you were saying about the early ideas in America, an idea that was originally put in place to make people understand that violence wasn't only physical, I think has now sometimes become quite dangerous because it now becomes an exclusory factor. And you see these discussions happening between judges in the family court and, say, a family report writer, where the judge is, who writes the social science report about the family, where the judge is saying to that person, so was this coercive and controlling though? And if that person says, well, I don't know that it was, and there wasn't physical, but none, or maybe there was one physical, you get this thing where it becomes very easy to go, oh, that's not
right. That's not what we care about.
Family violence.
Right.
And
Yeah.
I'm sitting beside a family law practitioner here as well, so I don't know what Anne-Marie would say, but I just wonder how that notion has I guess, played out in things that you've looked at and how we might deal with that here.
Yeah, so what's interesting to me about it is that it's playing out in a similar way in the US. So when the typologies were first introduced, from my perspective, it was a way of saying, we don't know everything about this yet, right? And there may be different ways of looking at this, and we need to think about what the different ways of looking at this might be. In the book, I talk about the typologies as just a way of saying, okay, well, maybe it's not all this one thing, maybe it's something different. But you're right, that in the States, it's been used differently, right? Because we don't care about coercive control particularly at all. But what we do care about is situational couple violence and being able to dismiss it. Yes. And to say this is not actually domestic violence and therefore it is not relevant to a custody determination, to a visitation determination. I think Michael Johnson has got to be appalled at the way that the typologies are being used. I can't imagine that this was his goal in any way, shape, or form. But there's been a split in the US and UK research between family violence people and feminist intimate partner violence people from 1970s right, with Murray Strauss on the one side and the Dobashes and others on the other side, and taking the same information and looking at it very differently. I think this is just another instantiation of that. But the danger of it in the States has been the dismissal, not of things that are just emotional, because we've always dismissed that, right? But the dismissal even of physical violence when it's situational couple violence as opposed to coercive controlling violence, which we only still think about in the course of as physical as well. And I think you're right. The problem that we have in our field is that the potential for misuse of pretty much everything that you can think of is there, and we've seen it happen time and again, and I think emotional abuse is my favorite example of that, right? That if we were to do something more serious about emotional abuse, I truly believe that the people who would end up charged with it would be women, vastly disproportionately, in the same way that since the inception of mandatory arrest in the United States, the rates of arrests that have gone up the most are rates of dual arrests of both parties and the arrests of women. And so that concerns me in exactly the same way, but we are seeing the same exact problems, and we have scholars saying, wait a minute, it still matters, even if it's not what you want to call coercively controlling, it still matters. But it's a great way for the family violence people to say, no, you only have to care about this one category and not the other three categories. And the other thing, and I think I said this to you the other day, or I said this to someone the other day, situational couple violence is the idea that out of the context of a bad situation, somebody was violent to somebody else, but it's not an ongoing course of behavior that involves all the different things that coercive control does. But it seems to me that pretty much every coercively controlling relationship starts from situational couple violence in one way or another. And so how do you know where you are in that spectrum? And I think that makes it very, very difficult as well.
Leigh, can I echo Zoe? Thank you so much. That was just so wonderfully thought-provoking. And from my perspective as a law practitioner, I was really interested to hear about that paradigm shift you made in terms of advising your client that this is the way to progress this. One of the things that some of the organisations that I'm involved with in developing best practice manuals struggle with is how to have that option, I suppose, for a non-legal response resonate with lawyers and family lawyers when we're sitting across from a client who's describing this situation that we are immediately assessing from a totally subjective point. Did it cause you fear? Am I going to get you over the hurdle within the act? To taking it not less seriously, but seriously on a different level.
Yeah, it's a different way of so I'm a clinical law professor, so in the States, part of what I do is train law students to represent clients, and they do that under my supervision. We practice a kind of law that's in the States is called, it has just gone out of my head, I can't believe that happened. Client-centered lawyering. And the idea of client-centered lawyering is that the client's goals have to be at the center of any representation. And it's not collaborative practice exactly, because that really has to do more with the lawyer's roles within things. But this is really about creating partnership between lawyer and client, so that lawyers and clients are working together, with lawyers bringing legal knowledge to the table and clients bringing the knowledge of their lives to the table to help clients make choices that best suit them. And so the language of client-centered lawyering is all about goals. So what I teach my students and what I do with the few clients that I still see is to start always from that place of goals. And it's not, a goal is not the same as a legal outcome. So your goal is not to get a protective order, your goal is not to get custody. Your goal may be to be living safely with your child down the line and having some kind of co-parenting relationship with your former partner. Or your goal might be to have that former partner not be in your life in any way, right? But it's different than a legal outcome. When you start from a conversation about goals, and when you are willing to accept that there are legal and non-legal options as solutions in any legal matter, you have a very different conversation than kind of the one that I used to have with my clients, which was all about, do I have grounds for divorce? What are the things I'm going to ask for? Can I get a protective order? Which was exactly how I thought too. Because then we're thinking about, so I have clients for whom going to the legal system, I have a client right now whose partner is in jail for abusing her. And he better not see the videotape. He doesn't know that she's had a kid. He didn't know, he went into jail before she knew she was pregnant, and she didn't tell him, and she ended up, because he settled, not having to testify. He has no idea that this kid is out there. And the question that we're dealing with right now is, do we file for paternity and custody while he's in jail or not? And, you know, I could tick through the legal options, right? But there's a really important non-legal perspective on this, which is, I don't want anything to do with this man ever again. And so the question then is, do you take the risk of not filing anything while he's in jail and hoping he never finds out about it? And so that's, you know, that's the kind of conversation we have to have. It's a similar conversation to when people want to disappear, right? When they want to just take off, which is kind of, what are the non-legal options here? What are the legal options? Which one is going to best protect you? If I put a custody order in place, then you're stuck with whatever visitation happens. But if we don't put a custody order in place, there's no, you're not going to violate anything by keeping the kid away. So those are the kinds of conversations we have. And they're different. I'm a big fan of client-centered lawyering. I think it makes a tremendous difference for the way that we practice, and I think my students feel that too.
I think all thinking family lawyers practice that way. Unfortunately, there are
very few. There are unthinking family lawyers as well.
One last one.
Can I just ask you if you could talk a little bit more to that issue in relation to the system that you'd like in a criminal justice response, which is a lot more collaboration between the prosecution and lawyers and the victim. And you spoke about a line, you know, where is the line of, and to talk a little bit more about, I mean, that's what I've sort of, I'm from the Women's Legal Service, my name's Angela Lynch. That sort of, you know, when is it in just in an assault situation that she can say, but when it's grievous bodily harm and the injuries are so great to her that we as a community go, right, we have to do something here. We have to respond to this in a different way. Then, you know, like it's that, yeah.
Yeah, look, it's a really hard question, right?
Yeah.
The state has a responsibility to keep its citizens safe, right? And the state has a responsibility to intervene when the polity is disturbed in some way. But I think for me that conversation is about, will the intervention of the state make the victim's life better or worse? Will it keep her safer or less safe? Will it endanger her financially? Will it endanger her emotionally? What is it going to require of that victim? And that's a very different way of looking at the responsibility of the state than most people. So the follow-up question that I usually get to that is, what if there are children?
That's right.
And so, and I think that's a fair question. The way that I do this talk doesn't really give me the chance to talk about that. But what I would say to that is, I really truly believe that when we're allocating power as between the victim and the state, the victim should have the most of the power. And that's scary in some ways. I mean, people are going to die. I would say people die the other way too, when the state has all the power, but either doesn't exercise it well, or the women do everything right and still end up dead. So I think that's not a fair. But in the case of children particularly, I think the state has an independent responsibility. So when there is reason to know, and not just to believe, because a lot of the work of child protection is, in the United States anyway, is done on just an assumption that every kid who's exposed to domestic violence is harmed in ways that require state intervention. And I think the work around children and domestic violence doesn't say that. It says that kids are not helped by exposure to domestic violence, but also that kids are resilient. So if we know that there is harm, and if the mother is offered services and supports to help mitigate that harm, and if for whatever reason she chooses not to avail herself of those things, then the state has an independent responsibility to step in. But, you know, even in cases of grievous bodily harm, at least I would want that assessment to be done, right? Is this prosecution going to be more helpful or more hurtful to this victim in the long run? And then to weigh, okay, so is the benefit to the state more important than the harm that's going to be done to this individual by doing it, right? So say, I don't know, say we can construct a world in which we have reason to know that prosecuting in that trial is going to cause her so much mental anguish that she's going to go into a depression that she doesn't pull out of for years. I think that's a difficult then balancing to think about. Is it then, you know, and the other part of it that makes this all hard is that we assume convictions. When we start to talk about prosecution, we assume convictions. But convictions don't always happen. I had a client who went through a hellish trial with tons of evidence and really put herself out there, and the guy was acquitted. And what that did was empower him, and it destroyed her. And so I think we have to stop assuming convictions when we have those conversations as well. I'm not pretending that any of this is easy, but I do think we have to get to a place where at least we're working through those things together. The state, I think, is going to step in when it feels like it wants to step in, but at least we can make the state more responsive to the needs of individual victims as we get there.
But at that point, she would need not just the criminal legal advice, she would need at that time also the family law advice and the child protection
Right.
advice to make all of the ability to make all those decisions. And also you would think, victim advocates there as well
Absolutely.
in relation to assisting her through if she decides to go through a prosecution through that process as well.
Absolutely, and I think one of the things we've done poorly in the States is that our systems are pretty fragmented from each other. Not that I want the family system and the criminal system working together, but I want lawyers for people subjected to abuse to be liaising with the criminal system, understand what's going on in the family system, and understand what's going on in this protective order system and the child welfare system, so that we're giving people good, really, truly good advice. And 95% of the family law cases in my state of Maryland, which is a fairly progressive and fairly well-resourced state, at least one party is unrepresented. So we're talking about this as though we assume that people are actually going to have counsel to help them work all of this out, and most of them won't.
Right, thank you. I think we'll have to leave it there, but you will have the opportunity to continue the conversation over morning tea with Leigh. I'd like to thank MP Donaldson for coming and sharing your thoughts on how this work is progressing at the government. A particular thanks to Heather Dalkos for putting this all together and for attracting such an excellent audience. And Leigh, particular thanks to you. We are extremely privileged at UQ that you chose us to come and work with. It's all credit to Heather and her team, I know. But thank you for doing us the honour of sharing your work and your wisdom with us. We really appreciate it.
Thank you so much for having me.